do it all along and just nobody does it. But I figured what the heck, I'd at least try it and see if I could get it to work.
Did you spell out 43rd or 4th?
No, it was 43RD. Just nobody does it. But I figured what the heck, I'd at least try it and see if I could get it.
You can see we've been on YouTube with all that crazy toy crap.
You're broadcasting. Just in case.
I can't find you.
Good morning, everyone.
Good morning, Judge.
I am, it always takes a minute to get everybody in, so I've still got people popping up in the waiting room. So if y'all bear with me for a few minutes till I can feel comfortable we have everyone. You know, I don't know what's happening over here, but this is going in and out of being connected versus not connected. I mean, it was, see,
Yeah, it looks like the cord's loose.
not that it's integral to the operations of the court today, but
A little wonky anyway.
well, yeah, it's weird. That's the way it came.
Really?
Yeah, every time she cleans, it
It messes
it
up.
flops over. Yeah.
Well, that one cord back there was a little loose.
Well, that doesn't appear to have solved the problem,
No,
does it?
it's to make it work.
Nope. Here we go. Yeah.
Good.
Well, for now, we'll see.
We'll see.
All right. Good deal. All right, Kaylee, I guess let's go ahead and fire the recording up here. All right. Thank you. Good morning, folks. This is the civil docket in Barron Circuit Court. I normally just take these, call these in chronological order unless there's some special reason to call something out of order. If anyone, for example, is somebody is waiting for you in another court or whatever the case may be. If that is the case, let me know. If not, I'm going to just go ahead and start calling. Is that Miss Barry? Was it? Yeah.
Yes, it was.
All right. You probably have a family court
I do.
to get to. Yeah. All right. That's fine. Your case that I believe that you are here for is 19 CI 629. Is that right?
City of Glasgow,
Yeah. City of Glasgow versus unknown heirs of Ralston.
Austin, correct.
Hall. Yeah. All right.
Your Honor, that's my motion on behalf of the Buyer Housing Authority of Glasgow.
Yes, sir.
Judge, I'll just summarize what we found. We retained Kelsey Barrett to run the title examination for us, for our office, and she has provided me with a report. I'll try to be as succinct as I can. She started by using the deed book and page number that was contained in the judgment in order of sale, and that led her down a rabbit hole to determine that that deed book and page number really was the title source for some property out on the Haywood Cedar Grove Road. She went to the PBA office. They did some checking for her, and it looks like that at one time a guy by the name of Thomas Albright owned that property on Haywood Cedar Grove Road. So she believes pretty confidently that it's not the correct source of title and description for 502 South Morgan. She believes that it may at one time have been owned by the Lessenberries and that maybe there was an unrecorded deed from them to the Ralston heirs, and that may be the problem. But the housing authority would still like to purchase the property because it's within their geographical area, but we would like to get the court to reform the judgment, whatever needs to be done so that we can get good title to it. I did speak with the city attorney, Danny Basil. He was going to look into it. I've not heard anything further from him since that time.
Well, two things come immediately to mind, and the first thing is that the bidder at the sale should not be forced to buy something that was, if it was different than what was advertised, based upon what, the description that was given in the complaint that initiated the action in the first place. So I don't think that is a problem. The second thing that jumps immediately to mind is that it's going to be, I can't immediately think of a way to reform the judgment without knowing whether or not there are people out there that should have gotten notice of something and didn't get it. Certainly the heirs of Ralston did not ever respond or anything like that, but the piece of property that the city put its bid on may have not even been owned by those folks. And if that's the case, then, we would have an obligation to find out. So it seems like to me, and I'm just thinking out loud, but it seems like to me that of those two options, the only real viable one is to allow the purchaser to opt out of the bid and just send that back to the plaintiff and have them either amend the complaint or voluntarily dismiss it and refile a complaint with the correct information in it, or whatever option the plaintiff wants to take. Ms. Berry, what are you thinking? We haven't discussed this at all, so I probably should have let you go first before I started spouting off, but what are you thinking?
We just need that judgment to be voided in some way, whether the action is dismissed. I'm not sure what the basis of it is, except it was not correct,
Right.
Or whatever, or an order voiding that judgment based upon the improper parties, whatever the court would find appropriate. But clearly this can't be enforced. And the policy is to verify with the PVA that that's correct description, well, to the extent that the PVA can verify a description and the location and all that. So apparently this is something that's been incorrectly referenced for quite some time.
Yeah, if my memory serves, this is a piece of property. Of course, the city is the plaintiff, so I'm assuming that what happened was it was some variation on either
Abandoned is what it was.
the property had to be demolished because nobody was taking care of it, and it was a health hazard or whatever the case may be. So I don't think I have any grounds to actually dismiss the action, but I do have grounds to vacate the judgment, and which would also, I think, ipso facto, get the buyer out of the
Right.
no judgment, void the sale and vacate the judgment, and then let the plaintiff just decide how it wants to proceed, whether it wants to voluntarily dismiss it or file an amended complaint or whatever. And since Mr. Basil's not on here, I guess, Mr. Alexander, if you don't care to contact him just at your convenience and let him know that that's what we did, so he'll know what, that he needs to make a move in one direction or the other.
Sure will. Yep.
Is that fair?
Yes, sir.
All right, then that will take care of that one. I think we can just prepare an order on our end and do it.
Okay.
But another reason I don't want to dismiss it, just frankly, is because there are costs and everything.
Yes.
That's
Obviously,
what I was wondering.
obviously the commissioner has just kind of a fixed cost anytime a case is referred to the commissioner for sale and then the sale's not consummated, and those costs are still going to have to be paid. So I don't want to dismiss the action. I want, and in fact, I'll put in the order that we do that you already have fees. There's already been an order approving your fee. So
There
if
is.
that's going to change, I'll just make a note in my order that I do that fee still needs to be paid.
Along with the costs,
Right, the fee and cost, sure.
advertising cost, and that may be all of it at this point.
Yeah, whatever's in your order, I didn't
Okay.
to memory, but you submitted an order right back after Christmas and I signed it because your
Okay.
fees
And
were
the
sale.
fees won't change because it's the minimum. It's $400 for the master commissioner, so they won't change even no matter the outcome of the sale or no sale.
All right, fair enough. I guess another thing we'll need to remember, and Dana, this probably falls in your bailiwick here, I guess, but if there's another sale, you know, we would still have all of those advertising costs would come up all over again. I mean, it wouldn't be that
Right.
if they got paid once, that doesn't mean they didn't get incurred twice. So, okay.
Right.
All right.
Thank you.
Thank you all.
We're excused, correct?
Yes, yes,
Thank
correct.
Judge, if I could, I'd like to take a quick, I see Mike Maloney on here. I hadn't seen him in a long time. College fraternity brother of mine. Mike, how you doing, bud?
Hey, Rich, how are you doing? Long time no see.
I know it, man. Good to see you. Judge, may I be excused?
Yes, thank you.
All right.
All right, Barrett versus Travelers.
Good morning, Your Honor.
Morning, Judge.
Morning, Judge.
Believe we have all the players here for that one, correct?
Yes, Your Honor.
This is plaintiff's motion to set a trial date. Is that right?
Yes, sir.
I guess you all have, everybody has probably tried to get a trial date at some point in the last 9 months. And so you kind of, I don't have to go through the speech, but you all know that these are, whatever I set's going to be necessarily a lot more tentative than it normally is, because who knows, right? But I can sure set you one. In fact, I just got I think one of Miss Marley's compatriots over there in her office that they had settled a case that I had set for trial. And I'm trying to remember when it was, but I think it was August. And if that's the case, then we probably could just insert this one. Yeah, I think that was, maybe it was August 25th, 26th, and 27th. I just have one settled that was set on those 3 days. It may have been that one, it may have been a different one, but anyway, if you all can live with that, that may be quicker than what you thought you were going to get. It may be further away, but that'd be the first time I'm going to have a couple days in a row.
Hey, Your Honor, this is Mike Maloney for Travelers. Just to sort of apprise you as to where we are in the case. We took the plaintiff's deposition a couple of months ago. The plaintiffs are scheduled to take the adjuster who was on the file, I think later this month. We've exchanged written discovery, obviously, and there was a lot of underlying materials, as you may recall. The underlying case was litigated pretty hard. So there is more discovery to be done. We'll have to take depositions of the underlying lawyers in the case in terms of various things about settlement negotiations. There will be experts involved. We anticipate filing dispositive motion on behalf of Travelers. And so I just give you that background because I think August might be a little bit early. I think we can certainly do something this year. But given the way things have been going so far over the last year, I just wonder if that's a little premature.
Yeah. Anybody want to weigh in on that or agree with that or disagree with that?
I always take the position that if the court's ready, we'll get our stuff done. So if that's when the court has time, that's fine with us, at least on my calendar anyway. If there's any other time later in the year, that's fine too. But if you're ready in August, we'll be ready in August.
Well, I had a case.
The only thing that I would wonder is, I know you gave us the 3 days. These cases, depending on how early you start and how late you keep, it may take 4 though. And I'd rather say that on the front end. I'd rather, have 4 and need 3 than be begging for another day if the court's calendar doesn't accommodate it.
Sure. Well, and I guess my standpoint on that, and just for logistics, I guess, is that if we're talking about wanting 4 days, then we're basically going to be talking about March. I've got 3 days in August and 3 days in October, and then a day here and a day there, and 2 days here and there and that kind of thing. But in any of the cases that I've got that would be a 4 day type of deal, those have been set for a while. And really and truly, when I look at my calendar, the first time I've got 4 days in a row is March 1st through 4th of 2022. So if that's gonna, and I'm not trying to say, oh, change your mind and tell me you don't, don't tell me you
Right.
need 4 days. I'm just, being honest with you that's where we would be if we needed 4.
It's easy. We'll hustle on our end, and Mike, you don't get to put on any witnesses, so it makes it a lot easier.
Oh yeah, I could
Yeah.
probably come up with some rules that would, yeah.
That's usually the way it goes for me. Plaintiffs get 2.5 days and I get 30 minutes.
The one thing that I would say that factors into this is that I do not know what constraints we will be operating under in August in terms of choosing a jury. And if you think about that brief little window of time that we had where we could have conducted a civil trial, which was a couple of months there in the fall, we did not have any, but we had a couple that were imminent. And we had a lot of discussion about how most of our jury selection in civil cases, quite frankly, is done in a couple of hours at the most. We just, we usually have a pretty efficient way of doing it. I don't know what everybody, I haven't been in any other circuit courtrooms in 15 years, so I don't know what they do. But you can count on following the rules that we would have had to follow this summer and fall. You can count on probably at least a day just to pick a jury, because you can't put all the people in the courtroom anymore. We can only fit, if we were doing jury selection, we could only fit at the most 20 people in here at a time. And you can't pick a jury of 12 or 13 people out of 20. So you know what I mean? You'd have to do jury selection probably 3 times to get a jury. And so instead of 2 hours, you'd be talking about 6 hours. Does that make sense, what I'm saying?
It does. What was your October date, Judge?
It would have been 28, 29,
You said 28 and 29?
27, 28, and 29.
Yeah, I've got another one set at that same time in Indiana. I'll do whatever. I mean, I think I just am concerned about that August date, the way things have gone. And I know we're going to have dispositive motions. It'll be pretty, probably complicated, take a little while to get through with the briefing.
Yeah.
And I just think something a little bit later than that's going to be best, or we're going to be back asking you to move it.
It makes sense what you're saying. And I guess another factor is that if we don't open this back up for trials, we just got the Supreme Court order saying that we couldn't try anything until April. You all probably would not be surprised to hear that we have had to put off almost countless criminal cases over the last 9 months. And those are going to have, especially if anybody is in custody, or of course you've got speedy trial issues. So, we may be in a situation where we've got civil trials, and I've always kind of made it a point not to double and triple set things without warning everybody, because I don't want people to get ready for trial and then get a call from the judge's office that they're getting bumped. But that may have to happen. And, I've got a murder case set next month that we're going to have to pass because we're not allowed to have trials. It's been set 3 times. All 3 of which were during this pandemic. We've tried it 3 different times and we haven't been able to, we've been under the no trial rule. That kid is in custody. He's been in custody the whole time. So whenever we open back up, we're going to have to just kick somebody out of the way and put his trial on and do it, so that's not the only, so I guess if what you all are telling me, I mean, maybe the best idea would be to shoot for this March time, but then if you're going to file some motions, maybe integrate that into the order that gets done by August. And, that way we're not waiting around. Everybody there'll either be something happen or there won't, as far as that goes. And it'll get taken care of.
I think that makes a lot of sense. And that
That's
way, if
fine.
we, depending on what happens after the dispositive motions, if the case is still alive, we can talk about mediating it at that point, before trial. So I think that would make some sense.
Okay. So that was looking like March I guess you all may not have things scheduled that far out, but some of you might. That was looking like March 1st through 4th.
Okay,
What I was proposing.
that's okay for the defendant.
That's fine, Judge.
Fine.
Okay. And this is 17 CI 665, right? 17 665. All right, why don't we do this? Why don't we set a, why don't we just go ahead and agree on a day in April, in August? And what we could do is any motions that were going to be filed would, you would file it by that day. I would put it on the docket. We could get together and discuss if we're going to need to do a briefing schedule or some sort of time frame for everybody to file their responses and replies. Is that fair?
Sure.
So it could be any Monday in August. Take your pick.
I can do any Monday except August 30th.
Okay.
Why don't we do the 23rd? Because we'll have to get through these other depositions to get to that point for the dispositive motions anyway.
Yeah, that's fair. 23rd, that'll be at 9 o'clock. And, I anticipate that even if everybody in the world is vaccinated and all that other good stuff, that by everybody's going to be so used to meeting remotely that a lot of our stuff will still be handled remotely if everybody wants to. So we'll call it 9 o'clock, and unless we talk about it in some other way between now and then.
Okay.
Yes, I have a Zoom link that's going to still be active then, and in case things change an awful lot from between now and then. So be just like today. Okay.
So we'll file dispositive motions by the 23rd, and then when we talk with you on the 23rd, we'll decide then when responses and replies are due.
Yeah, that's fine. And in the order, the trial setting order, I don't suppose from what you all are saying that I really need to put anything in there about discovery deadlines or anything. It sounds like you all already have all that kind of worked out, right?
And if not, we'll submit. If not, if we run into a problem or want to get something set for a particular date, we can work together and submit an agreed order if that's okay with the court.
That's fine. That's
We
fine.
probably just need an expert disclosure deadline for each party.
Right.
Okay. All right. Well, what are you thinking? Because, I want to have it, I want to, plenty of time for you all to be able to, if you haven't already decided who your experts are going to be. But it seems like to me that the expert disclosures probably at this stage of the game, you all are able to do those pretty quick, aren't you?
Well, we got to get the underlying discovery finished first so experts can actually read it.
Oh, okay.
So, I mean, typically in a case like this, whatever the plaintiffs want for their deadline, I would just ask for probably 45 to 60 days after so we can get their expert deposed. But it'll just really be determined by when the plaintiffs want to disclose theirs.
Yeah, I mean, what I don't want to do is get back here in August and have everybody say, well, we didn't have time to get all this done because the disclosures, were made in June and then July, and we didn't get time to get all the, you know what I mean? So why don't I give the plaintiffs, why don't I give you all 60 days from now or 90 days from now and give the defendant 45 days after that. And I don't know what days those are, but I'll count them up and put them in the order.
We might need a little more time than that, Judge. If we can maybe make our disclosures due something like August 1st and theirs due 60 days after that.
Why don't we do August and September and then maybe move this hearing to the 1st of October, Judge? Still gives us 5 months before trial to get the dispositive motion done.
Okay, well, all right. So yeah, we'll call the pretrial October 11th instead.
Perfect.
And then we'll call the disclosures would you say August 2nd?
Okay.
And then,
60 days after that for defendant.
all right, so that still puts like October 1st. I mean, that's
Yeah, that's gonna be too close.
bumping up real close.
You want to just make it, well, we can make it 45 days. Either that or bump that 10, 11 date back a couple of weeks, either way.
Well,
I just, by the time, when we take their deposition and get the transcript back and get it to our expert to look at it to finalize their opinions, I usually ask for 60 just because that allows enough time, but we could probably jam it in at 45.
well, I'm just wondering how you're going to disclose by October 1st. And even if we put the pretrial on October 25th, I mean, that's going to give you 3 weeks to get a deposition scheduled and taken and get the report
Right.
transcript back. That's might be pushing it. I don't know what they're doing these days.
Well, what if we do late September for my disclosures? So we get like 7, instead of 60 days, we get, maybe like 7 weeks.
Yeah.
And then we
All right,
do
here we
end
go.
of,
August 2nd for plaintiff, September 27th for you guys, and put the pretrial on October 25th.
that's great.
The only potential, well, I would hope that isn't going to be a problem. Usually that last week of August is when the circuit judge, continuing education program is every year. We had to cancel it last year. It's been rescheduled for the spring of this year, so I doubt they'll want to turn right around and do another one 6 months later. So, but I suppose if we were doing it by Zoom, I could just do it from the comfort of whatever state park they have us in.
Judge, I'm sorry to interrupt. I have a 9:30 in federal court.
Yep.
And
I'll do yours next. I'll do you right now.
You.
Okay? Because I think I'm done with these guys.
Your Honor, thank you.
Thank you.
Thank
Judge.
you.
Have an excuse?
All right.
Yes,
Thank
my big
Be
excuse,
quick,
please.
I think.
All right. So are we talking about the Mitchell and Regency Park?
Yes, sir.
Yes. Judge, this is
Okay.
our joint motion to talk about the trial date. It's set for trial currently in April for a 2-day. Based upon what you talked about with jury selection this morning, I don't think 2 days will be sufficient, given jury selection. That being said, I'm also not confident that the courts are going to open up back in April. And especially if you have murder trials like you talked about today. I think, our trial is 2 weeks after the courts open back up. I just
Yeah, I
think-
don't disagree with you. I mean, I don't disagree with you. I think that it's going to be, I'm not confident at all. I mean, we all talk about the vaccine and all that stuff, but I mean, nobody around here, if you're not over 70 and you're not a frontline medical worker or a police officer, you still haven't gotten it. I would say that it's not going to trickle down to us normal, regular people. Cook might be some kind of frontline, vital city employee or something, since he represents all those cities.
I wish.
Well,
Yeah,
I know the president of the water company, not working for the chairman of the board over the water company was considered an essential frontline worker. And I guess that makes sense. If something goes wrong with the water supply, you need decision-making authority and all that. But so, he was one of the first people to get one.
Well, I hear the thing to do is a lot of Walgreens pharmacies are distributing and giving out the vaccine. And typically by Thursday or Friday of each month or of each week, they know if they're going to have excess that will expire. And if they have vials that are going to expire, they have to give it out instead of destroying it.
Just
Really?
show up and hang out at Walgreens.
Just go to Walgreens. Yeah. You get a lot of points on your card.
Yeah,
Right.
I heard last week they had like an hour window where they had a certain amount left over, and it had an hour before they couldn't use the vial any longer. So
Wow.
Interesting.
there's
Yeah.
some things like that going on that I've heard.
Well, do you want me what do you think about that August? I have 3 days in August and 3 days in October that you heard me talking about before. I can live with either one of those.
Unfortunately, I can't do October. I already have 2 trials set in October.
Uh-huh.
Um,
What were the August dates again?
27, 28, and 29.
25, 26, 27.
No, 27, 28, and 29.
I have that as a Friday, Saturday, Sunday. Maybe
Oh.
my calendar's messed up.
Oh, no, I'm looking at October. I'm sorry.
Okay.
Yeah, you're right. I was,
So what is it?
yeah, August 25, 26, and 27.
And if we didn't do August and we're not doing October, anything in 21 after October or?
Well, of course, you know, I could set it with the understanding that it would be second in line to something else, because pretty much all of the rest of I've got November and December, both of those months that are taken up by I've got a 4-week trial and a 2-week.
Yeah.
So, I mean, that just kills now, you know,
Yeah.
obviously if one of those settles or if both of those settle, it's a different ballgame, but, you know, I've got one of those cases has 25 plaintiffs in it. So
Good grief.
I don't know how it could settle, but you know, I mean, it could partially, you know, I don't know how that would work out.
Be first on the August date?
Yes.
What do you think, Lauren? Too soon?
Well, I'm going to be out June and July. That's the only reason August is worrisome for me.
Well, we don't have to do it then. I don't care.
Yeah, I know. I just hate bumping all the way until spring of next year. Because after that is the next available March.
Well, that was the next time I was going to have 4 days. Let me look and see what else
3 days.
Yeah, I mean, I've got January of 2022. I've got a 3-week medical malpractice trial. Then February, I've got a 3-week medical malpractice trial.
Well, let's just take August. I'll make it work.
March, we've got what we talked about. And then that case that I just said in March is the last trial I've got. So, I mean, anytime after March 1st, 2nd, 3rd, and 4th, we could do it. But I mean, other than that, we'd be.
Let's just take August.
Okay.
Maybe that'll motivate us to chat some more.
Yes.
We've already mediated this once, Judge.
Yeah. Well, and I mean, you know, things change as you move on through. So
That's right.
I'm not going to twist anybody's arm as far as mediating it again, but I mean, there may be something to talk about.
Take your standard trial order, Matt. You think that'd be fine?
That's fine. I think the main thing for us is that we don't have to file any pretrial by Friday of this week. So as long as we don't have to do that, we're good.
I mean, is there any discovery to discuss or has it all been done? Or
we've got a little bit more to do, but I think we can work that. We work fine together on that.
Yes.
I mean, it seems like to me, all I'm going to have to do is an order that sets the trial date. We'll set a pretrial, right, you know, if that's possible, right before, and we will, you know, I'll have a pretrial compliance in there, but I don't think I need to discuss the other things because they were already in the order. So
that's fine.
You all are already pretty well ready to go.
Yeah.
We'll work it out.
Matt and I know what we need to do and we'll get it done before
That's right.
trial.
All right. So can I put it on August 2nd for a pretrial? Monday, August 2nd?
Yes.
9 o'clock?
Yes.
Okay.
All right. I'm going to hop on with Judge Laney King before he kicks my butt.
Thank you.
Thanks. Thank you, Judge. See you later.
Bye-bye.
Have a good day. Thank you.
You too. I better pencil that. The last case I have on here is Crown Asset Management versus Metter. And there does not appear to be anybody on here with respect to that. Case. All right. I'll deny that motion. I think I may have Wayne County Detention Center on here.
Can you hear us?
I can. How are you?
I'm doing good. How are you?
Well, I'm fine. We're a little early. You know, we're on the slow time, so we're not starting for another 25 minutes.
Oh, okay. That'll be good then.
Yeah. I don't know if you want me to just let, what I can do is just stop this and then you can join back on. Do you want to do that? Or do you
Yeah,
want?
let's do that because I've got some. I'm going to have some district court per.
All right.
I'll go ahead and get them in here and get them out of the way.
All right, perfect. I'll just let you sign off and then when you're ready, you ought to be able to just jump right back in. Okay?
Okay, thank you.
Yes, sir.